in Valencia in person, and then him, Claire Bune, is also in the room online. So if you want to sit here, so everyone can see you. The second PhD candidate to make the presentation is Zarja Jude. I'm sure that you, I think
it's Zarja Jude.
Zarja Jude.
Yeah, Zarja.
Zarja Jude. She is a PhD candidate from London School. She studied at the University of Ljubljana and the University of Cambridge as a PhD student at the London School of Economics, under the supervision of Dr. Andy Summers, Professor Milan Bogdanovic, and Eduardo Bajstrocki. And the title of her thesis is titled A Semantic Framework for International Tax Regimes and Computational Legal Analysis. And in order to discuss this interesting paper, we have here with us, and I really thank her, and sorry for not being able to know her in person here in Valencia, Professor Claire Bune. I'm sure that I have not pronounced properly, but you can correct me in your turn. Professor Bune is a professor of tax law at the University of Seoul in the Republic of Korea, and she's Assistant Commissioner for Taxpayer Advocacy at National Tax Service of the Republic of Korea, and previously she was a member of the National Tax Administration Reform Committee, the Committee on the National Tax Appeal, and the Tax Legislation Construction Committee on the National Tax Service. To both of you, thank you very much for attending the seminar, for making the presentation available. Do you want to sit here so everybody can see you during the, because you can move here to that. Okay. Is it being recorded? Stop and record. Okay, stop. Okay. So whenever you want, the floor is yours.
Okay.
Just click.
Can you hear me okay?
Yeah.
Amazing.
Okay. Press here.
Yes. Okay. Yeah. All right.
Yeah. Whenever. The floor is yours.
Thank you. Hello, everyone. My name is Zarja Jude, and I'm a PhD student at the London School of Economics, supervised by Eduardo Bajstrocki, who many of you know pretty well. Before I start, I wanted to perhaps give you a quick heads up that what I will about to present probably differs from most of other presentations, in the sense that it is not a deep dive into a very specific tax topic, but instead my study explores how we could structure and process legal data more efficiently, not surprisingly using artificial intelligence, and in that sense uses tax law as a case study for reasons that I will elaborate on later on. Besides Eduardo, I'm being supervised by Andy Summers, also from the LSE Law School, also specializing in taxes, and Milan Bogdanovic, who is coming from the Department of Statistics, and he is supervising in particular on the technical aspects of my work. A bit context on my research stage. So I have just finished the first out of 4 years at LSE, meaning that I'm quite early on in my research journey. So I'm very, very happy to be able to present to an entirely taxed audience today, hearing your feedback that I may incorporate later on. However, I was presenting the work that I'm about to speak about at different occasions throughout the last year already, in Cambridge, Stanford, Slovenia, London, and Chicago, where my work has earned me a runner-up prize at the doctoral track at International Conference on AI and Law, the ICARE, which has been around since 1987, and it's kind of a go-to place for the researchers between the AI and law intersection. But as said, I've not presented yet to a tax law audience, so I'm really, really happy and excited to hear what you think about what I'm doing. So the title that I'll be unpacking today is towards a neurosymbolic approach to structure and process international text flow. And the towards there stands because it is a theoretical proposal of how I think it would make sense to design systems that combine both the strengths of symbolic AI systems. We'll tell about a little bit more about what they are, with the large language models that are being widespread used in the more recent days. Now, over the summer, so after receiving the prize in Chicago, I got a confidence to stop refining the proposal and start with the implementation. So over the summer, I built a working prototype that kind of implements the framework that you're about here, but the prototype is built on the contract law example because of the existing data structure frameworks and the benchmarks that I could immediately use to evaluate my performance. So I will not be disclosing the prototype today. I'll be focusing on the proposal, but if you want to hear more about, I'm happy to comment afterwards. Okay. So I'll break down this long, complicated title in the upcoming speech into more manageable pieces, but essentially I will be talking about how we can design systems that combine LLMs and the earlier AI approaches to structuring intelligence in a way that is grounded in the legal theory and philosophy. And the last bit that I want to explain before we dive deeper is just the bigger picture behind what I'm doing in my PhD project overall. So what I'm about to present today is just the first out of 2 research questions. So it's how can symbolic and neural methods be effectively combined to structure and process international tax law? However, the outcome of this will be a theoretical proposal, and I don't want to stop there. Instead, I want to validate the practical applicability of whatever I will come up with, which brings me to the research sub-question of whether the feasibility of the proposed combination can be validated through a case study focused on individual tax residency tests. And here is where we come to the tax law example. Altogether, the first research question explores what the law can learn from computer science and in particular AI. So how can we structure and process legal data more efficiently, better than what we do today? However, when I was researching this, it became clear that the exchange could also be made the other way around. So what could the AI community potentially learn from the law, from the lawyers? And what I mean by that is that one of the main limitations that the AI systems currently face is lack of explainability. We cannot explain how the decisions by LLM models are made. Meanwhile, we lawyers have very sophisticated techniques that provide well-established frameworks for providing the reason justification that legitimate our choices and decisions through frameworks and through techniques that have been refining for centuries. And in that sense, I do think that the legal reasoning techniques could be insightful, if not helpful, for also thinking about the explainability in the era of AI, which will be probably what I will delve into towards the end of my PhD journey. And today I will be focusing on the very beginning that will open up to the later discussions. So how can we combine the symbolic and neural methods to effectively structure and process international tax law? And as promised, we will go through this research question in 4 parts. I'll first explain what the neural and symbolic AI methods are and how they complement each other. Then we will take a look at how could we combine them to mimic the legal thinking and reasoning process. And here I will be referring to the theory of adjudication by H.L.A. Hart. The third part will be about what applications could this combination have in law. And at the very end, we will take a look into why tax law. Why have I chosen this specific area as the most suitable field to validate my proposal on? Starting with the neurosymbolic AI. So when you think about the AI today, we oftentimes think about the stuff like ChatGPT, Claude, or other large language models, or even like autonomous agents and things that are emerging nowadays. But these are fairly new applications or imaginations of what artificial intelligence stands for. Earlier approaches to modeling intelligence were much simpler than that. So what researchers in AI and law research were doing beforehand, before the emergence of LLMs, is that they predefined legal rules. So they explicitly encoded them in a system that mimic the human logical thinking and problem solving. And the example that I think is quite informative to use is on the left side. This is an extract from the paper that I was returning to throughout my first year of PhD. And in this paper, with this equation, they define how we determine whether something that we are looking at is a banana. And what they say is that, and I will just stand up to make it a bit clearer. They say that the banana, which is a concept that we're interested in, exists if and only if all the factors that determine a banana and are being relevant for being a banana are true. And this decision-making process very much resembles what we in law understand as deductive reasoning. So we have an abstract rule with certain criteria, and then we have a certain case at hand, and then we have to identify whether this abstract criteria is met by what we are looking at in order to make a conclusion whether the rule applies and the legal effect that the rule predefines is triggered. The neural methods, on the other hand, take a fundamentally different approach. So if you would ask a neural AI whether something is a banana, they would answer this question by looking at all the bananas that exist out there. So if we imagine the ChatGPT, it's all the bananas that exist on the internet. And from this corpora of information, identify the banana-like features that indicate identify the patterns that indicate the banana-like features, and this is then matched against the input that we are looking at. And with this pattern matching, they then identify the likelihood whether something that we are looking at is a banana or not. And translating this again to how the legal reasoning terms is that very much resembles what we call the inductive reasoning. So consider that you're applying a certain rule that involves a broad concept. And what the lawyers do when they deal with the broad concept is that they check if they are defined in the statutes, they check if they are interpreted in the case law, they check if they are explained in the regulatory guidelines, or perhaps if they are discussed in the scholarly articles or any other different sources that they may rely upon. And from this corpora of legal information, they deductively identify how it's best to identify the concept in the given case at hand. And as I'm drawing these parallels between the symbolic AI and deductive reasoning and neural AI and inductive reasoning, it becomes clear why if we want to mimic how the lawyers are thinking, it makes sense to combine both. And now that we know what the neural and symbolic AI approaches are, we can also take a look at how they complement each other. So we said beforehand that the symbolic AI systems require you to predefine the explicit rules up front. Now imagine predefining, formalizing, encoding the entire law in a code. It's a very difficult exercise, which has been attempted from a very long time ago, ever since the 80s, and has proven again and again to be very demanding. So formalizing the law, which is very vague, which is very complicated, and sometimes does call for flexibility, and sometimes resists to be deduced in on a logical structure, just prevented the symbolic systems to really be adopted in a widespread sense. So this manual and rigidness was preventing them from scaling up in the legal applications. However, the large language models, which can process vast amounts of legal text much faster and can consider context pretty well, seem to be able to overcome the rigidness and the inflexibility of the symbolic systems, but they do come with the limitations of their own. Namely, the two main reasons why they are not, despite their achievements, widely adopted in legal practice is that firstly, their decision-making process is opaque, so we cannot understand how the LLM came up with the decision. At the best, what we can do is to understand the likelihood or the pattern matching that they performed, and the lawyers don't really trust what they don't understand. And the second reason is that they are so-called non-deterministic, meaning that if we give them the same question, it's not 100% sure that we will always get the same answer, and this results in lack of reliability and ultimately the lack of trust. Now, these problems, trust-related problems, did not exist in the symbolic AI era, because if you have like a software systems where you predefine the rules up front, you can reckon that a certain permutation, a certain combination of factors will always result in the same conclusion, and you can always trace back the reasoning process back to the original source, which is what the lawyers are usually doing. And with this comparison, hopefully it becomes clear how both neural AI and symbolic AI come with their own set of limitations that can, though, be balanced by the strengths of the others. Again, reinforcing the case that if we want to mimic the legal thinking process, it makes sense to combine both. And this is an emerging research field that is coming up more and more. The researchers are figuring out now what is the best way to combine them, and there is not a unified answer to that. So when I was questioning this, when I was answering this question myself, what I decided is the best way to do, so in answering how to combine the neural and symbolic AI, is to go back to the very fundamentals of legal theory and legal philosophy. So I found the answer that formed the fundamental of my proposal in the theory of H.L.A. Hart. So H.L.A. Hart is one of the most influential legal philosophers of all time. So he was living in the 60s, and his most well-known work is called The Concept of Law, which, when you think about it in the AI era, it is how do you conceptualize law that you work with? What are the concepts that how do we understand what the law is? It comes up to a whole new context of something that has been written decades ago. And H.L.A. Hart, just for context of those who are not as familiar with him, he was a proponent of a philosophical paradigm called legal positivism. And how legal positivism was defined from the others is that they rely primarily on the explicit legal provisions and do not consider as much other factors like the standards or morality and other aspects in the legal interpretation, which is why the legal positivism was later on criticized by later philosophies that also are very widespread nowadays. However, when I was selecting the philosophical paradigm for my project, it was really important to me that whatever I will be coming up with is as objective as possible, as unbiased as possible, and available to everyone. So if I wanted to apply more sophisticated paradigms than legal positivism is, I would be effectively deciding what the law should be by implementing the things in my program, and I didn't want to step in those shoes. So I decided that for the purposes that I want to prove in my project, it's better to go with the legal positivism with all the limitations it has, and then leave it open to potential further extension that could implement more normative constraints that come up with later philosophies. Okay, that's about the positivism. Now going to Hart. His philosophy is enormous, but the part that is really important for my project is called the theory of adjudication. And this is on the right side of the slide. So a bit of context of what was happening in the 1960s when Hart was drafting this philosophy is that there were two extreme views at the edges of a continuum. There was one camp that was called the strict formalists, who were saying that had we only defined the law strictly enough, then the judges would mechanically apply it without using any of their discretion whatsoever, meaning that all judicial all the judicial decisions would be the same. On the other hand, there were rule skeptics or realists who were saying that the rules actually don't matter as much. That's very simply put, but it is the judicial discretion that actually makes the decision making with sufficient authority to bind. And Hart found both these extreme views inadequate, so he took a more balanced approach between both. What he said, in essence, was that in law, most situations are easy. Easy means that they can be resolved with applying the legal rules alone. However, because the law is using natural language as a medium, and natural language comes with the open texture, there always will exist some margin of uncertainty. And his famous example is that if we are deciding whether something is a vehicle, it is easy to say that the car is a vehicle, but it is hard to say whether a motorized wheelchair qualifies as one. And in these hard cases, Hart says that the judicial discretion is not only acceptable, but it's necessary in order to keep the legal system flexible, that it can correspond to novel unforeseen situations that will be continuously occurring in an evolving society. So in other words, and that's where it becomes really important, is that the easy cases so the rules can resolve easy cases, can guide hard cases, and resolve and constrain the judicial discretion, because the discretion is not arbitrary, but it is bound by the rules. And now thinking of the parallels that I was doing with the AI before, the proposal of my PhD in essence is that the AI systems would take a fundamentally similar approach, meaning that we could use the symbolic AI to resolve easy cases, to guide the hard cases, and constrain the discretion. In this new novel context, the discretion would be the form of neural AI, so the LLMs. And perhaps to give you an example of what I mean by that, to imagine it more clearer. So suppose that we have a question of whether a car is a vehicle, and that is, we can imagine this as a human input to a system. And now suppose that in the knowledge base, we do have a rule that a vehicle is any means of transport, such as cars or lorries. So we see that the concept car is both in the input and in the knowledge base, so there is a direct match between the both, which means that we can make a deduction that a car for sure is a vehicle, and this can be derived by symbolic AI, so we can also trust it 100%, and it would always affirm. However, the knowledge base of the legal rules can be a bit more vague. So the statute can also just say that a vehicle is a means of transport without specifying car as a specific instance of it. And in that sense, what we can still do is that when there is no direct match between the input and the knowledge base, we can use the large language model, so the neural AI, in order to fill the interpretative gap that exists between what we know and what the input is asking us to do. Meaning that here we would ask the LLM a constraint bounded subtask of whether a car is a means of transport, because that's the gap that we have. And importantly, the output that we would derive would be merely a prediction, not a 100% certainty. But the beauty of having this system is that you can always add new knowledge to the knowledge base, meaning that suppose that we have the same vague rule, but we then now have a core decision that does say that a vehicle is a car, meaning that again is a direct match between the input and the knowledge base that we have, just on a different level, which again means that we can use the deduction. And this essentially means that the more knowledge we put in the system, the more we can rely on the deduction, which is reliable, and the less we need to rely on the LLMs that are flexible and scalable, but do not provide the trust. However, when we do not have the knowledge, the LLMs do better than the system breaking and crashing, which is what was happening with the pure symbolic systems that were developed up to nowadays. Okay, so that's about how I see that the neural and symbolic components would be combined in the system. And we were talking about the hard theory of adjudication, so how the judges are deciding cases. And in the context of AI, the deciding the cases corresponds to the process that is called legal data processing. However, in order to even be able to process the legal data, we have to do a task up front that did not exist in hard time. And this is called the legal data structuring. So putting the data in a form that machines can understand and process in the first hand. And I see the benefit of combining both neural and symbolic approaches at both stages. So my PhD is more focused on the second stage of legal data processing, but on the structuring part. I mentioned beforehand that structuring legal data has proven to be a very demanding task, but there is a lot of research now emerging when the researchers are using the LLMs in order to structure the legal data. And that is not yet perfect, but it is proven to be much more efficient than the manual processes that were being done beforehand. And they also are exploring how you could perhaps use the LLMs first and then use the human in the loop in order to just correct, or perhaps train the LLM models to do it themselves automatically better and better over time. So that makes the entire part on the legal data structuring part neurosymbolic. But I said before, that's less of a focus of what I do. Then once you have this, once you have the legal data structured, so they are ready to be processed, then you can use this knowledge base as a baseline. And whenever the knowledge runs out, so whenever the input does not match what you already know directly, then you only call the LLMs for the bounded subtask where the knowledge is not explicitly given. And in that sense, the neurosymbolic, we use two different methods of combining both at different stages, whereas what I was focusing mainly on now is the processing part. Okay. Now how this would look like. So I only have 10 more minutes, which leaves me with very little time with that. But I just wanted to show you a little bit how like the legal data structuring part works, because I found that this is a bit hard to imagine for lawyers. So on the left side, we have a legal text from Article 4 of the International Tax Treaty by the OECD. And what I did is that I structured a graph where nodes represent legal concepts and the edges represent the logical or normative dependencies between them. So how I did that is, yeah, this is just the explanation of the graph. So I said the edges are the dependencies between the nodes, and the nodes are identified a bit more. So they have a unique identifier that's understandable to machines. Then they have the term that is understandable to humans. The reference links back to the source that incorporates this term. And this is important because if you want to perform the systematic interpretation right, then you have to understand also the meta rules about how the different legal acts correspond to one another. So in order to understand the importance of different nodes, you do want to consider other aspects. Then the type is just whether the concept is decided on a binary basis or does require comparative weighting. And then the data structure that I'm using also allows to incorporate additional contextual information that may help the system to understand the concepts more correctly than they would without this context. Okay, and then how this legal data structuring exercise looks like is that you identify different things in legal text. So I was identifying legal concepts that were given explicitly and inferring them. Then some of the legal texts are the attributes. Then the anti-concepts are about like what kind of obligation or permission or prohibition you need to do. The dependencies is how they follow one another. The legal effect is what follows if the rule is given. And then the metadata is something that I considered as a as something that identifies in which source the rule is contained, and everything else was considered as a legally non-significant text. But now if we follow the graph structuring part, so where the nodes represent legal concepts and the edges represent the dependencies between them, these texts start to look something like this. And then once you visualize the legal text in this, it's much more, it's in a sense much easier to understand how the legal system works and how it correlates to how different concepts correlate to one another. And once you have the graphs in this sense, then it's very easy to manipulate them. So this was just changed with one line of code. Here the focus is on the sequence of steps, and here the focus is on the centrality, meaning which legal concepts are more important or more connected with the others. So then you can do very fun exercises with that. Okay, and then now I only have like 5 more minutes for the most important part for you, which is like why tax law. And I wanted to point out here quickly that I selected a tax law based on my first-hand experience because I was working in tax before I started my PhD. But then I complemented like what I experienced firsthand with the papers that I came across. And the overarching reason for selecting tax law as a case study is its complexity. So tax law is notoriously complicated, as you all know. It's usually the longest piece of legislation in many jurisdictions. And as a consequence, it is very unappealing to many lawyers. All of you are, of course, a big exception. Though, if we think of it from a machine perspective, all this rich context, all this rich regulatory data that's available can provide a lot of context to the machines. So that makes tax law more amenable to machine processing than many other domains. Another reason is that tax law involves numbers, which again can be intimidating for lawyers, but makes the entire domain much more verifiable. Because the problem that many legal AI solutions are facing nowadays is that you cannot really verify whether whatever they come up with is true or not. And this algorithmic nature of tax law enables us to make the process of verifying our results much easier. And the last thing is that compared to other legal domains, tax law stands out for its requirement for predictability and certainty. So as opposed to, say, contract law, where sometimes the uncertainty at the time of the contract formation is preferred, taxpayers usually appreciate being 100% sure about how much taxes they need to pay, by whom and by when, which results in very detailed directives, oftentimes delivered in a very technical language, that are, again, frustrating for humans, but are easier to being modeled and automated from the machine perspective. And then the implications of this tax law complexity are, probably obvious to all of you. So one of them is that Because we have the complexities, this creates a lot of arbitrage in the legal rules, which enables those who can either acquire or afford the specialized legal expertise to benefit, normally on the account of those who are less resourced or the tax administrations, which eventually results in the deepening social inequalities. Another reason is the weakening the democratic legitimacy. So if you have unresolved ambiguities, these ambiguities are then resolved by the administrators or by the judges, not by the elected lawmakers, and this kind of like stands at odds with the principle that no taxation should occur without representation. And then the trends of what I'm talking about, there are quite a few empirical research papers that are investigating the rising complexity of law overall. But the three areas that are continuously being validated as growing with the highest complexity rate are the financial regulation, social welfare, and tax state, which means that the problems that I'm discussing today will only become bigger and more pressing in the future. And this is kind of like the official reasons of why I have selected tax law. The unofficial reason is that tax law is the only area where all the lawyers that I work or am in touch with get incredibly excited when I tell them about what I do, because they imagine the artificial intelligence being introduced and helping them with their work, making it a rare instance of the community excitement about AI doing some of the legal work. Which is why I plan to be figuring this out for the next 3 years. And now I would be very happy to hear your thoughts. Thank you.
Thank you very much. Very exciting, very hard and difficult topic, at least for lawyers. But I think I would say we are kind of concerned, if not very much concerned, about the rising of artificial intelligence and how it will affect and will develop our tax systems, taxpayer rights, and functions of the tax administration. I want to give the floor to Claire Bune, Professor Claire Bune from the University of Seoul. I can see now her there. Thank you very much for coming here from Seoul. The floor is yours.
Thank you for inviting me to this seminar. And then my name is Hae-jung in Korean, and you can call me Claire. My last name is Byun. That's a correct pronunciation. And Zarja. I don't know how to pronounce. I'm sorry. Say again.
It is Zarja.
Zarja.
Yeah, correct.
Is it correct?
Yeah.
Okay, Zarja. Yes, it's a very interesting paper to me because this is the first paper I read on this topic. So I thought maybe I have been away from academia for the past 4 years. That's why it's new to me. So I searched other papers in Korea, but I realized that no one in Korea has not worked on this topic. So it's very interesting. And then basically I agree that it would be good if we can find a way we can use AI systems more when we work on tax. And I hope you find that way. But because we live in different countries, and then we have quite different legal systems, that's why I have some different ideas. And then, so, because actually I'm not a kind of the expert on this topic. Maybe my understanding might not be enough. So if I misunderstood, hope you correct me. The first question I have on your paper is about the title. So you say to structure and process international tax law. So I'm wondering, to structure international tax law, you mean, or to structure legal data. So what I think is those works are quite different. So that's why the roles of AI must be different according to what you mean. So hope you make it clear. Can I ask what you mean here?
Yeah, so I use the term of structuring law, not legal data, though I could use the notion of legal data. But I go with law because law is mainly expressed in text anyway. So the textual format is the default way of expressing the law. So textual data is how we are expressing the law in. And that's why structuring and modeling law, I thought it kind of is clear that then it pertains to legal data, but it is true that it's more accurate to refer to legal data, and law is a broader concept than that.
Okay, thank you.
I noted it down.
Okay, thank you. And then what I understand is that you try to combine the both approaches, the symbolic approach and the neural approach. That's the main topic of your paper. That's what I understand. Is it correct?
Yeah, so the main contribution of my paper is to propose a novel way of how the neural and symbolic AI could be combined. Because there is some research that is exploring different approaches, and also this research is very scarce, as you correctly observed. But the way of I'm proposing and backing it with the legal philosophy is an entirely novel approach to it.
Okay. Yeah. So, what I am wondering is that because the nature of a neural approach, so basically the nature of neural approach that does not fit well with laws. That's what I think. So even if you try to combine those systems, the limitation of neural approach would not go away. Just still it has some kind of problem to use in a legal system. That's what I think. So if you can find a way to overcome those limitations, that would be the best way. But otherwise, still we have to think to use Euro approach. We still have to consider the limitation of Euro approach when we use Euro system in legal system. That's what I think. So I'm wondering, do you think you can find a way to overcome the limitation, or still you try to suggest just to combine those approaches or things like that?
Okay, that's a very good observation. To answer you quickly, I don't think I can overcome the limitation of neural AI approaches. These are very complex computational domains, and I'm a lawyer, so I don't have the skills to play around and change the LLMs themselves. There is also a big research topic in computer science domain working on the explainability and interpretability. And I do reckon that there will be improvement on that part as well. But when it comes to using the neural approaches for the legal reasoning processes, I think that what we can do is to accept the inherent limitations that they have and then constrain them to the point where we are comfortable with the limitations that come with the neural approaches. And the comparison that I like to make here is that when you're thinking about the human interpreter of legal rules, the humans too come with very similar limitations that the neural AI has. So if you think about the opaque decision-making process with the LLMs, you could also argue that the human brain or human decision-making is a black box that you cannot fully understand, or maybe you can rationalize it with expose, but it's not something that is inherently available to everyone upfront. Or even like the non-determinism that I was talking about before. So producing different outputs given the same input that LLMs are oftentimes criticized for. You could also argue that if you ask different judges the same legal question, they may come up with different solutions. Or even if you ask the same judge about the same question at different points in time, they may answer it differently. The most famous research paper probably is the one when they were deciding against the criminals before and after the lunch, and they came up with different verdicts. So, so I would say that the limitations that are inherent to the neural AI do exist also in the methods that we are using nowadays. So if we are comfortable with if we're comfortable, I think that the limitations in the neural AI do not make it can still make it acceptable or like tolerable for the applications in the legal domain. It just matters for what kind of applications we limit them to, and in what sense we give them the freedom where we accept that the uncertainty or the untrustworthiness that they come with is something that we can live with. And maybe like to give you an example of what I'm talking about is that oftentimes people see the use case of what I am researching for in the courtrooms where like the AI system would be deciding the cases, but I think that this is not the correct use case. Like you can use the system that I was describing before merely to, let's say, provide legal information or provide clarification, or maybe like in the process, like if you think about the user as a lawyer who is coming up with a legal advice, if you have certain point that can make it easier to navigate the complexity of tax law, I think this is already useful.
So you mean you try to restrict the users, is that correct?
No, I'm trying to restrict I'm trying to accept the limitations that come with the neural AI. So these are the non-determinism and the opacity primarily. And then I try to limit the use of neural AI in a system only where the limitations that the neural AI systems comes with is tolerable. And how this is implemented is that you have neurosymbolic systems which implements the legal rules as a symbolic AI, and only where this symbolic knowledge runs out is where you call the LLMs. So LLM is not the default, it is what fills the interpretative gap when no explicit knowledge is available, which is very similar to what the humans are doing.
But anyway, in that case, that the users they could have some different results from neural AI, right?
Can you rephrase the question?
I'm sorry. In that circumstances, you say, I still think the users would have different results from neural AI. Is it correct? My understanding is correct?
I have not yet identified who the user of my research would be. Like at present, there are several different directions that I could go with, but I think that I have to let more time. So I have to first build and work on my research a little bit more, then build the system, and then once I have more tangible things that I work with, it becomes, I think, easier to determine in which direction it would be the most appropriate to shape it. Like where I see the research evolving at this stage, but the opinion may change, is that if I'm working in the international tax, so on the individual tax residency tests, the user that will benefit the most from having a tool that will be able to navigate the complexity in multi-jurisdictional scenarios best are the policymakers, because they are the ones that are concerned with the entirety of the system. Let's say if you're a taxpayer yourself, you're not concerned with everything that exists with the tax. You just want to know what applies to you. But the policymakers are the ones that are concerned with how different legal systems and concepts interact with one another. So that I think that is what I see as the user at this stage of the research. But as said, as the research evolves, this might change.
But anyway, because the problem I would like to point out is that because of the nature of a neural system, the nature is a non-determinism. That's why people could have different results then people will interpret in different ways the tax laws, then that could cause the tax disputes. That's what I concerned. That's why, because you mentioned then you did not classify any users, but I think if tax authority has one result, but the taxpayer gets another different result, then maybe we can anticipate the tax disputes. But even in international law areas, there are more people are involved. So taxpayers in other countries and then even tax authorities in several countries. In that case, it's hard to use and believe the neural AI. That's right, what I think. But maybe it's it's just my concern, or but still I think I hope you think about that issues as well.
So can you just confirm if I understand that correctly? So you're concerned that the system, because it contains the neural components, which are non-deterministic, may result in the tax disputes because it would come up with different interpretations.
Yes.
Okay, yeah. So solutions to that is that you can always embed more knowledge into it. So if you want the system to be more deterministic, you can expand the knowledge base. And as you expand the knowledge base, you limit the neural component more. That's one thing. And the second thing is, and that's actually what I implemented in the prototype that I am not showing up today, but how the things work there and how to prevent the duality of possible outcomes, how I handle that, is that so I had the knowledge base set up, and then this knowledge base was determining which requirements have to be filled out in order for certain rules to be triggered and then traverse to a different legal state. And then the LLMs were being bounded only to smaller subtasks, and then they were answering the mini questions that then compiled up into like a bigger reasoning chain. And then what I did is that whenever the LLM came to one conclusion, then it's a bit difficult to explain now because it's kind of visualized behind me, but so I set up a counter argument for what LLM came up with, and then I was testing out if the opposite could be argued to what LLM came up with in the first place, and then this kind of like ensured the defensibility, or like to understand. So this enabled then me to not come up only with one reasoning chain, but to basically test and to set up the reasoning process in a sense that you do not stop at one interpretation, but you always check the other side of the coin as well, which is also what lawyers are doing in practice. And then this enabled me to come up with a protocol that came to a much more thorough legal reasoning exercise than what the LLMs are doing if you just put them up prompt and they answer in a zero-shot manner. Does this make sense? It's a bit complicated.
Okay, another question I have is that because you mentioned social fairness.
Yeah.
Yes, but I'm wondering because if you are not a tax professional, then how you can understand the result from neural AI, especially whether the result is correct or not?
Sorry, can you say that question again?
I'm sorry. Yeah. So usually tax professionals can understand, and then they can see whether the result from AI is correct or not. But usually, if you are not a tax professional, it would be very difficult to tell if the result from AI is correct or not. That's why I'm wondering if we adopt neural AI, could it be helpful for non-tax professionals to interpret tax laws? That's what I am wondering.
Yeah, that's a very good point. So it's about the individuals not being able to recognize when the system output is wrong, because of the complex nature of the tax law. Do I understand correctly?
Okay.
Yeah. So I mean, this is true, and I'm right now in the stage of trying to come up with a system that works and then validate like whether it works. And I know what the correct answers are. But it's true that if you would want to come up with something that the lay people could use, you do need to be concerned about the quality of the outputs before they are being requested. And this requires to have some measurements or like quality reassurances in the system, which at present are not yet implemented. But this is kind of like scheduled in the timeline after I validated like what I came up with works and it's fine. And then the next step of thinking about is how do you deliver that to who is the relevant audience, and then how do you assure that whoever the relevant audience is gets the outputs that are of sufficient quality that they require.
Okay. And so I have another question, but it is not quite directly related to your paper. But anyway, you mentioned that on page 9, the unresolved ambiguities shift interpretive authority from elected lawmakers to unelected administrators or judges. So because these days in Korea, it's kind of a social issue. So that's why I'm wondering why you say its interpretation of law is like making law. Is it kind of common sense in your country or in Europe, or because I'm really curious.
I'm not sure if I understand the question. So could you maybe just explain what the context in your country is to understand the problem better?
I'm sorry?
Yeah, so could you just explain the context in your country so I understand the problem?
Yeah. No. It's kind of complicated. In my country, it's kind of a political issue. It is related to political issue. That's why, because I'd like to make my question simple. So is it common sense interpreting law can be lawmaking?
Oh, yeah. So I get where you're pointing at. And yes, and the question that you're giving is actually very philosophical. But yeah, so I'll just answer it by referencing again Hart's theory, because he was saying that when the judges are deciding the cases, so when they are interpreting the law, they are effectively creating new law within what is already known. So that is like one view of it, but I mean, I'm not sure like what the question is related to my system, but for sure, like he was saying that also in the sense that in common law, when the judges decide the cases, their decisions may have a binding effect in certain circumstances. Now in civil law, so I did my undergrad in a civil law country. That's technically not the case, but then many jurisdictions do impose a rule that it's either expected to follow the established case law, or it is not, let's say, constitutional to deviate from the established case law without a reasoned justification, which doesn't give like a direct binding effect on the decision, but it still gives the judicial decisions a lot of authority for the upcoming ones. And in that sense, I would argue that when the judges are deciding the cases, they may influence how the law is being interpreted in the future, and especially if that influence is binding, then in that sense, they can be seen as creating the new law. If it's not binding, it can be just like as a persuasive authority, but the influence still persists.
Okay, thank you for all your answers. That's all my questions. And then good luck with your thesis. I hope to learn about your research in the near future. Okay, thank you.
Thank you for your comments. I've noted them down and will consider them. Thanks.
Thank you. We still very interesting debate, I would say. Questions and answers. I do not know if there are some other people that once, yeah, Joachim, I see raising his hand. So Joachim, whenever you want, the floor is yours.
Thank you very much, and thank you, sorry, for this really interesting presentation and for the discussion, of course. I have a couple of questions. I don't know, should I limit myself to 1 or 2 questions, or may I pose like 3 or 4? What would you say?
Sorry?
Can I have a couple of questions, or
Sure.
time constraints?
Still time, and
Okay.
we have even time to recover, so don't worry.
Okay, so then I'll start with a couple small comments that are not really that relevant, but I just wanted to make them to give you some additional flavor. First of all, from a continental law perspective, at least, there are some situations where you might think a case is easy based on what you read in the statute, but in fact, it's not the case, and the problem is you can't necessarily tell beforehand. For example, if you take Hart's example of no vehicles in the park, you might say, okay, if a statute says a car is a vehicle, then it's clear if a car drives into the park, that can be fined because it violates the rule. But a judge might come to the conclusion that actually the legislator forgot to take into account atypical situations like a police car in pursuit of a criminal. And if the police car drove into the park pursuing a criminal, that would not be violating the rule because that is an unwritten exception. So it's a car, obviously, and still you wouldn't find them, or an ambulance or whatever. So sometimes we call that on the continent teleological reduction, reading an exception into the law that's not in there because we assume that the legislator accidentally forgot about it. That makes a seemingly clear case hard. And so that is something, you just might want to consider. It's of course easier if, as you say, for me, a clear case is also when we have case law, but even then, there is jurisdictions like Germany where even high courts can change their opinions, where lower courts are allowed to deviate. So there's no stare decisis like in the US. So it's never 100%, or it's in much fewer cases 100% than you might think. That's my first comment. The second is more a question, but I have a more important question. So it's a question only if we have time. What would you train the neural part of your model on? So is it trained on like literature, on case law, or is it trained on the entire internet? Because I mean, as you also, I think, acknowledged, lawyers will have a certain set of methodology when approaching hard cases. It's not arbitrary. So in my country, we would look at the context, at the purpose, maybe at the legislative materials, and then there's still, of course, some discretion, but there's a clear methodology. So just searching, in the extreme, what the internet might come to a conclusion that with an 80% probability, a boat is still a vehicle, might not make any sense in the specific legal context we're talking about. So I think, to have that, have a useful reasoning by the neural system, you probably need, obviously, the right training data to train it. And if that is case law again, where is then the difference to the 100% predictions, or rather not predictions anymore, but certainty that you would assume can lead to symbolic AI solutions? Because if you have a high court case in your model, that's a part for the symbolic AI, if I understood correctly, and not anymore for the neural thing, even though the neural thing would be trained on the same case law. And now I think the most important question I have is, why would you, or why would one actually need the symbolic part still? Because if I understood your paper correctly, you write this is all still for assisting AI solutions. You're not proposing to fully automate decision making based on this, which could be considered. But if you say it's all about assistance, then you have a human in the loop who will just get a recommendation, and the LLM will provide the human with a plausible narrative for its finding. Obviously, the human cannot really know how the LLM came to its finding because it's basically a black box. But the LLM, and that's different from earlier deep learning AI systems, will give a plausible narrative. And then if you have a judge or a taxpayer, or rather his advisor or her advisor, or if you have a tax administration official, that person can then check the plausibility of the result. And that person, and that's my point now, can check the plausibility as fine and as well in case of a say 100% solution, or in case of a 90% confidence interval for a prediction. So why would you need an additional symbolic AI pod that requires a lot of human resources, programming of decision trees, etc., for the parts which you earlier discovered as being 100%? If, you know, for the human, it doesn't make much of a difference because he will check the result anyways. And especially acknowledging that maybe even 100% cases are not necessarily so 100% all the time. To me, it would be much more interesting if you said, okay, I have structured the data, I have identified certain cases which say I consider to be 100%, which is fine for symbolic AI, which gives me transparency, which gives me certainty, and all the rest I leave to the neural AI. And then the legislator can decide, or the administration can decide, whenever it's based on symbolic AI, it's fully automated, goes through, you know, and then you can still go to court as a taxpayer if you're not happy with it. Whereas if you only have a prediction, then it mustn't be fully automated, then it will be assisted AI. And that could be really beneficial in practice, I think. You know, to the easy cases, so to speak, are done fully automated, whereas the hard cases are singled out for human control, and it's the system that decides which are which. And that might be quite interesting then. I have a final question about policymaker and the relevance of the system for policymakers, but I'll leave that out because I think I talked enough. Thank you.
Okay, thank you so much. I'll try to answer all three questions at once, and then just like touch on how it answers different parts. Because what you mentioned goes very well hand in hand with what I was doing over the summer. So when I mentioned that I was building the prototype on the contract law example, I did identify the main flaw of pure LLM approach when compared to a neurosymbolic approach. And how this turned out is that I was using as a prompt a contract law example. The contract law example for undergraduate course, they are normally very ambiguous. They allow for several different interpretations, and then they are given to undergraduate law students to see if they can detect the nuances and then argue for different reasoning paths that can lead to different legal conclusions. And the LLMs were not doing that. If you ask the LLM a legal question, they will collect the complexity of the legal narrative into a single interpretation. It happens every time. It happened every time that we were testing it. And when we added this knowledge graph that was constraining the LLMs, the knowledge graph was constraining them and guiding the LLM reasoning, meaning that it preserved the legal logic and it forced the LLM to take every step that was needed in a legal sequence. And then the LLM, because it was guided by the knowledge graph, it did interpret every reasoning step as it should. So it came down to a much more thorough and much, like as a result, more comprehensive legal analysis that much more reflected what the lawyers would come up with as compared to a zero-shot, like pure LLM baseline approach. So that's the answer of why we need symbolic AI, is that I think it really adds value in guiding the legal reasoning steps. Because if you think about the legal reasoning as such, is it very often contains very long reasoning chains. And if you use LLM that has, I don't know, 90% accuracy in a 10 reasoning step exercise, the ultimate accuracy for getting the right result will be about 33%, because it will be on par with on every reasoning step that comes. But if you have a knowledge graph that implements the deterministic rules about the legal structure, then the LLM will be guided and will be also more prone to come up with a better outcome. And then as I was doing this exercise, so my prototype did not work 100% without flaws. And when we were doing the error analysis, we identified that the errors in our system still concentrated where the LLM was guided by prompts, so not by deterministic rules, but when we just instructed the LLM what to do. And then we were thinking about how to overcome these errors that were still occurring, and we came up with two different strategies. And one strategy is that you just implement more knowledge, which is what I was also talking about before. But then we realized that there were certain things where the LLM was making a mistake that would be more sense to train it for a specific task. And one example of this was that the LLM oftentimes made a wrong decision about how the legal rules are assigned. And I think that the legal rule assignment is something that the lawyers do very naturally, and it's very easy for us to understand from context. But for LLM, it has proven to be a quite difficult task. But instead of implementing the knowledge, like the meta rules about how to assign different roles because the roles might be context dependent, etc., it came out that for tasks like that, it makes sense to perhaps train the model better, and then just for this specific subtask, make the LLM better as opposed to giving more knowledge in. So I would say that when I was using the LLM in the prototype that I did, I was using the general purpose LLM. I was not training anything myself, but it did come up to the surface that for specific subtasks, it would perhaps make sense to train it and optimize for that task specifically. Now, what I would like to point out though about using the LLM strength on legal data versus the general purpose LLM is that if you think about how the lawyers or what knowledge the lawyers, the human lawyers are using when making the decisions, is we are not only using the legal knowledge when answering the legal questions. We are combining the general knowledge and our specialized legal knowledge. And I think that for the general knowledge that we oftentimes use and is needed in practice, the general purpose LLMs could be better than the specifically trained LLM. So it's also like a design choice of where you want to optimize the LLMs for a specific legal task, and then be strategic about at which point you want to implement this in the reasoning pipeline, not just do it for the sake of it. And then I just to get into the point where some cases seems easy, I correct on that, and currently don't have the solution yet, but hopefully we'll have at the next symposium.
Perfect. Thanks for the debate. I assume that there may be some other questions, but since we are running out of the schedule, the time for the second presentation, I think that we can here stop and make a break. But before making the break, as suggested by Eduardo, we could take a global picture of all of us, both present here in Valencia and all other in Zoom. So if you can open your camera, we will put kind of all the cameras in there, and we will sit in front, and anyone here present wants to take the responsibility of being the photographer, it will be more than welcome. Thank you.
Yeah, thank you very much.
Nos ponemos aquí para que se vean ellos.
Yeah.
Espera un momento. We need to move a bit there. So at the end, Maria is out. But so ready, 1, 2, 3.
Nice.
Perfect.
Thank you.
Thank you.
Thank you.
We can come back at
Not yet, but I will. in 10 minutes.
25.
I'm at half.
So in half an hour. Okay, perfect. See you then.